Welcome to Tony Martignetti Nonprofit Radio, coverage of the National Conference on Philanthropic Planning, hosted by the Partnership for Philanthropic Planning. We are in San Antonio, Texas, on the Riverwalk. It's 2011, October 2011. My guest now is Aviva Boedecker, and she is principal of Aviva Boedecker Charitable Associates in Tiburon, California. Her conference topic is what to do when the donor dies. It's a pleasure to welcome her back to the show. Aviva, welcome.
Thank you very much. I need to catch you up on the latest news. I've joined the Sharpe group.
Oh, well, it must be very late because that comes after.
Absolutely.
Since this.
It's very new news.
Okay, then what is your title with the Sharpe group?
I'm a senior consultant.
In which office?
I am the San Francisco office.
You are the San Francisco
I
office?
am the West Coast office, to be specific.
The West Coast. Okay,
Yeah.
Well, congratulations.
Thank you very much.
No more Tiburon. Okay.
Well,
Is San Francisco near Tiburon? I don't even know.
oh yeah, Tiburon's just the other side of the Golden Gate Bridge.
Oh, okay.
Tiburon,
Okay.
So, yeah.
Senior consultant.
Senior consultant.
Okay. Your topic, what to do when the donor dies.
Yes.
Let's start with a rumor. I heard a rumor that I'm going to share with a charity that someone close to the charity has died. What should the charity do?
Well, it kind of depends. I mean, that's a lawyer's answer. It depends.
Yeah, but let's not go there.
No, we won't go there. But it does depend on how well you knew the donor, how close the donor was to the charity, on what you're going to do. Certainly, in all cases, you're going to find out who to write a condolence note to, if you don't already know. If the person was closer to the charity and there's time, you may want to go or send someone to the memorial service. You want to be careful, though, about sending flowers and things like that because it's not appropriate in every culture. And unless you're sure about the donor's religious, ethnic customs, don't send something.
Okay.
Just a condolence note.
But it could be appropriate to go yourself.
Oh, sure.
Go to a memorial service or a wake or something like
and
that.
Make a point of
Sit
telling
Shiva.
the family members, how you knew the person and how important they were and what a contribution they made to the organization.
Okay. Does it depend also on whether we have documentation of what kind of a gift there might have been for the charity, whether there is or isn't documentation?
No, because when we're doing, right after the person dies and we're sending condolence notes and going to the funeral, it's not about the money. It's about the relationship. And if you knew the person or the person was an alum of your university, you'd have the chancellor write a note. It's nothing to do with a gift.
Okay.
However, if you have reason to believe that the person had included your organization in their estate plan, then you need to start looking out for some notice. And again, it depends on whether it was a bequest. You need to get notice within a certain amount of time that the estate is being probated or that there's a trust. If it was a life income gift that your charity was perhaps the trustee of, then you need to get the death certificate and stop sending payments.
Yeah. Okay. The notice that you referred to would be a notice of probate, and that probate process. Why don't you just explain what that is? Remember, we have you're a repeat guest, so I don't know if you were in jargon jail on the first time, but we do have jargon jail on the show. So for people who might not know what probate means, what is that in just a sentence or two?
Well, when someone dies, all of their affairs need to be settled, and that includes everything from collecting all of their assets and getting them distributed to the right people to collecting all of their bills and getting those paid. There are variations on probate. Probate is just the legal process, and it happens through the courts, of collecting the assets and redistributing them to the right people.
Right.
These days, a lot of people have living trusts, which do not go through probate.
Right. They don't like that court-supervised probate process, and the living trust avoids that process.
Exactly.
To the extent that the person's estate is in the trust.
Right.
Yeah. Okay.
But whoever is handling the estate basically has to do the same things. It's just without court supervision.
Without court, right? Okay. But so the charity now has notice one way or another. Either they know because they've been involved in a life income gift, might have been a charitable gift annuity, let's say, or they might be the remainder beneficiary of a charitable trust, and they've known that in advance. Or it could just be a simple bequest, and they've
Yes.
now received this notice of probate. Now that means that in any of those circumstances, the charity has rights and responsibilities, right?
Yes,
Why don't you
exactly.
talk about those a little bit?
Well, if it's a life income gift, the responsibility is to make sure that the tail end of the life income gift is handled properly. First of all, was there a successor life income beneficiary? Because if there is, then you need to make sure that the new person is getting the income and it's not going
Okay.
to the old
And
person.
then let's just talk about the other example of a will.
And if there's a will, you need to find out what exactly was in the will for
Okay.
you. Make sure that you get the notice. Charities, well, any beneficiary is entitled to get notice if they have been included in an estate of some sort.
Okay. And so let's, now the audience for the show is small and mid-sized charities, so I'm going to stick more with the will example because that's
Okay.
the most likely for our listeners. Now they have that notice, but let's say they don't have a copy of the will because the notice doesn't always come, the notice of probate
Right.
only occasionally, in my experience, comes with a copy of the will. Is it appropriate to reach out and contact the attorney that's named in the notice of probate?
Not only is it appropriate, but it's really required.
Okay.
It's the charity's responsibility to get that notice because if you
Well, to get the notice,
to
but
get the document,
to get the will,
because
yeah.
if you don't know what's in the document, how do you know that you're going to get what you're entitled to?
Okay. Now, listeners may be a little apprehensive about calling a legal office, a law firm that's named in the notice of probate. How do they carry on the conversation? Like, what are they asking for?
They're saying, gee, I am from XYZ charity. We just got this notice of probate. We know that this was one of our donors, a close friend. We don't know what this means. Can you tell us? Ask.
Okay.
Just ask the questions and say, is there some documentation? Is there a will? May we have a copy of it, please? And of course, the answer has to be yes. Any experienced attorney, experienced law firm will expect to be asked.
Okay. And now, why do you say that the answer has to be yes for the request for a will?
Because it's a legal requirement that you're given that documentation.
And that will is a public document at the person's death, right?
The will is a public document. The trust is not, but any beneficiary of a trust is entitled to a copy of it.
Okay. Right.
And not just the gift portion, the entire thing.
Okay. And so I think it's important to just spell this out because people may not know that they're entitled to receive a copy of the will.
That's right.
That you're not calling the attorney asking for a favor.
Oh, no.
Yeah.
That is something that charitable organizations need to get over. There's this idea out there that charities are getting a favor, that they should be grateful for any crumbs that they receive.
Yeah.
That is absolutely not the case. First of all, they have a fiduciary obligation for the charity. They're a public organization to get the money. They have the same obligation to get the money that they're entitled to as they have to invest the money that they have appropriately.
Excellent. And because they've worked hard to earn that gift.
Right.
Right?
And the donor wanted them to have it. I think they have a responsibility to their donors to follow through and make sure that the donor's intent actually is realized.
Okay. I like to advise that in that same conversation, when you're making the first call to the attorney, that you just confirm the contact information. Because
Yes.
sometimes the notice of probate will be sent to the general office of the charity, but we'd like the information to come to a specific person.
Yes.
And we'd like the law firm to have that contact information. Anything more that you'd like to?
Well, and the other thing is,
include?
if you're not sure who to write a condolence note to, that's where you can get the information. Did they have a surviving spouse or partner or, other family member? Can you tell us the name, the address? Or if you don't want to give us the address, can we send it to you and you'll forward it on?
Excellent advice. Yeah, it's very consistent with what I hear generally and my own practice too. Ask the attorney. You write a letter to the person's name, and then have the attorney forward it to the family member.
You're dealing with people. So it's, never mind the fact that this is a donor. This is a person with whom you or your organization had a relationship. So, how would you behave if someone with
Yeah.
whom you had some sort of relationship passed away.
All right. So then, after this phone call, we've received a copy of the will.
Mhm.
What do we do now in this in the will example?
You read it.
Okay.
You look and see what it says. You don't just stick it in a drawer and say, "Okay, we've got
We've
this."
got
You
it.
need
Check
to
mark.
know
Yeah.
what it says. So it can say, say it says, "I give to my favorite charity $25,000." Okay, then you know you're going to get $25,000. That's easy. You might want to call back the attorney's office and say, is there an estimated time of distribution? What do you need from us? You're going to need our tax ID number if you don't already have it. You may need our IRS letter that we're a nonprofit organization. That's easy. And then just keep a lookout to make sure that you get it within the time frame that the attorney said. And it could easily be 6 to 12 months. Maybe even more.
For the actual check to arrive.
For the actual check to arrive.
Okay.
That's pretty simple. What's more complicated is if you're going to get the residue of the estate or a portion of it. And what that means is whatever is left in the estate after all the expenses are paid, after everyone else gets their $25,000 or $50,000 or whatever there is they're supposed to get, then there's going to be something left over. That is often the biggest part of any estate.
Right.
And that's the most complicated thing because you
Okay.
don't know what it is. So then you need to ask for an inventory of the estate assets because, if you're going to get 50% of what remains, you need to know what remains.
And how the other part that was spent. You want to know how the estate has been managed and money spent because you're getting 50% of what's left.
Yeah,
so you want to make sure that what's left is the size it's supposed to be.
Well, exactly right. And that's a little bit down the road because, first you need to know what there is. And then you do need to know what's left, and you need to know.
Okay, you were talking about the asset list.
Yeah, the
Okay,
asset
I
list.
see. Okay.
And you have to know, what fees have been paid, and are those reasonable, and whether the assets on the inventory were ultimately sold for or liquidated for an amount that is reasonable compared to what was on the original inventory. Because if there's an inventory that says a $2 million, piece of property in New York City, and then later on you get an accounting, and by the way, that's the other piece of it, you're entitled to get an accounting, which is when the estate closes or is about to close, there has to be, literally an accounting of what there was, what was spent, what was paid,
that's what I was
sold
referring to.
for. Yeah.
Okay.
And compare that, because if you had this $2 million piece of property on the accounting and it was sold for $200,000, what's going on here?
Yeah. Okay. Another concern in reading the will is the designation for the purpose of the gift.
Yes.
Now, what if in that bequest language that there's something that the charity may have trouble carrying out?
Well, that is why it's a really good idea, if at all possible, to get a copy of at least the gift language from the donor while the donor is alive.
Mm-hmm.
This is something that comes up. Should have thought of this before, but organizations often ask, should we ask the donor for a copy of the will or shouldn't we, in order to include them in the legacy club? And, no, because that's a cultivation tool. However, you do want to get, if the donor is willing to share it, a copy of the gift language. Not because you want to count up in advance, what we're going to expect, but you tell the donor, we want to make sure that we understand exactly what you have in mind and that we're going to be able to carry out your wishes and there are no questions later on, that you have us named properly. Sometimes there's like a local organization and a national organization. We need to make sure that it's the correct one.
I like to see the tax ID number and make sure sure that's correct in the bequest. Yeah.
And you can't always do that because the person doesn't necessarily even tell you that they have a gift planned. But that is why, whenever possible, you want to, and it's to protect the donor's intention.
Yep. Are there instances where the charity should engage an attorney to oversee this process?
Yeah. And it's Not always, but it's pretty often. Whenever people at the charity either don't understand what's going on or aren't sure, or if there's a dispute in the estate, even if the charity is not directly involved, get an attorney to either explain to you and even say, oh, yes, this is just exactly what's supposed to be happening. Don't worry about it. Or say, oh, gee whiz, this is, this is not right. One of the things the attorney needs to, or the charity needs to look for is that the costs and expenses of the administration are being allocated properly. It's not just a matter of whether there was some real fraud that, the $2 million piece of property was sold for 200, but do they say, oh, well, there are all these expenses, the siblings are fighting, we'll just assign them all to the charity's portion, It's like, no, that's not okay. You need to pay attention to that.
Okay. And the charity might find that expertise on its board, or maybe if there's a planned giving advisory committee, the attorney to help them with the process.
That's a good starting point, but I would suggest that there may be more work necessary than is just a pro bono.
Okay.
And also the attorney on your board or your committee may not have that particular expertise. It's a good starting point to say, take a look at this, what do you think? And then you say, who do you think we should hire to, it could be a very good investment of funds.
Especially if it turns out in that initial review, the attorney decides it's a pretty complex case and there is a likelihood of some kind of challenge, or even without the challenge, then you'd need to engage someone beyond
just to make sure that your interests are represented appropriately.
Yeah. How about continuing stewardship with the family?
That's important. I would not necessarily expect that the family is going to continue to give you more money. That may happen, but it is the gracious thing to do, especially if there was a fund that the donor set up, like for easy example, scholarship fund. Invite the family to see the scholarships awarded. Have the scholarship beneficiary write a thank you note.
And who would you send that thank you note to?
Well, it could be the surviving spouse or the children, or you need to find out who should be the recipient of that.
It might still be the case that you have to go through the attorney.
It might be, and that brings up another thing. Mm-hmm. Don't forget to thank the attorney.
Oh, very good.
People forget that. These bequests wouldn't happen without the attorney making them happen, writing the estate documents, and the attorney has done a lot of work in making sure that the estate is distributed properly, and sometimes standing up for the rights of the charitable organization.
So you'd like to be known as a gracious charity in the community, right?
Right. You want to be known as a gracious charity. You want to get the attention of the charity. You don't want to get into a situation where someone says, oh, I want to make a bequest to my favorite charity. And they say, oh, we've had experience with them. They really don't have their act together.
Yeah, that would be awful.
That would be terrible.
Yep.
So you want, you're not going to expect that the charity's going to, that the attorney's going to say, oh, this is a great charity, you should give them your money. But you want them to have a favorable impression of you.
Because if there's been a negative one, that one's apt to be shared.
Oh, yeah.
Yeah. All right. Well, we're going to end on the continuing stewardship note. Aviva Boedecker is the recently appointed senior consultant for the Sharpe Group in San Francisco, California, and her conference topic is what to do when the donor dies. Aviva, welcome. It was good to have you back to the show.
Thank you very much, Tony.
Real pleasure. This is Tony Martignetti, nonprofit radio coverage of the National Conference on Philanthropic Planning, hosted by the Partnership for Philanthropic Planning, and we're in San Antonio, Texas.